So there's a lot going on right now on the federal side of things in terms of immigration. There's been a lot of talk of certain federal agencies and officers searching individuals' persons, their home, their vehicle, taking them from their homes and vehicles. I'm a paralegal, so I'm not an attorney. None of this video should be construed as legal advice. The content of this video is going to be my legal understanding, as well as talking about the importance of knowing your constitutional rights, not only for yourself, but also if you're a criminal legal professional, for your clients as well, and the people who are just as impacted and who you serve. So in today's video, we're going to talk about search warrants. Do search warrants make or break a case, a criminal case? Why are they important pieces of evidence? For those of you who don't know, my name is Corrin. I'm the owner of Lucid Legal Support. I'm a freelance criminal paralegal, and I help solo and small firms across the country with criminal case management all the way from arrest to post-conviction relief. Without further ado, let's dive in. I think there's a common misconception right now, and I've talked to several people about this. Granted, these are people who are not legal professionals, but who have said that the Fourth Amendment, which protects people from unreasonable searches and seizures, only applies to U.S. citizens. I'm going to drop down the screenshot of the Fourth Amendment because it does not say citizens, it says persons. It protects persons from unreasonable searches and seizures, whether that's on your person, your car, your home, whatever type of property. There needs to be a search warrant in place. Now, obviously, case law has granted certain exceptions to this, and I'm not going to dive into that in this video, but if law enforcement agency is going to search yourself or your property, they need a search warrant first. Now, what is even a search warrant? So a search warrant is a legal document that's been reviewed and signed by a judge that gives law enforcement access to a specific location or person in relation to a crime to search and potentially seize. Usually this stems from law enforcement either got evidence or information that a crime occurred and they want to obtain a search warrant in order to investigate that and obtain certain evidence in order to charge this individual for a crime. However, they can't just do this willy-nilly and grab evidence out of thin air, obviously. The standard that law enforcement needs to meet before they even obtain this search warrant or when they're writing this search warrant is called probable cause. Probable cause means that there's a certain belief that a crime occurred, and it's not just based on mere suspicion, some type of evidence that a crime has occurred and that it occurred in a specific location or was involved with a specific person. Now, obviously, what is construed as probable cause is going to be different, potentially based on the jurisdiction and the judge that's looking at it. We all know that judges have a lot of discretion. Now, I will say, in my experience as a criminal paralegal, in about the 5-6 years that I've done this, I've never seen a judge deny a search warrant from a law enforcement agency, which I find kind of interesting, and it makes me call into question whether the judges actually read the search warrants or not. But another thing that I find interesting is that the judges are only getting a snippet of what law enforcement submit to show probable cause of a crime occurring. How can you make a decision on granting access to this person's property, house, car, whatever? So what the law enforcement officer, or usually the investigator, the main investigator in this case, does is they need to draft a complaint and an affidavit. The complaint and the affidavit need to list all the facts that would support probable cause. It needs to list the specific address that they want to search. It needs to list the time frame that they plan to do this. And it also needs to list the background investigation. What led them to seeing evidence of this crime, more than mere suspicion, to show probable cause, and then to ask for the specifics of what they want to be searched. The complaint has the main portion that the judge is going to sign off on, and then the affidavit is usually the supporting document that the officer writes up with their specific observations or investigation tactics, things that they've looked into, things that they've done. Once they're done writing this complaint and affidavit, they submit it to the court. It gets in front of the judge's review. The judge reviews it, and then he'll sign off on it, and we'll sign off on the location, date and time that this needs to be executed, yada yada, etc. Once law enforcement receives that order from the judge, they can go ahead and execute the search warrant where the location is in the search warrant that's been signed off on. They can't just go anywhere they want to. They need to execute it in the date and time frame that is in the search warrant as well. They can't just do it anytime. If they can't get to it in time, they need to reapply for a search warrant and get that signed off as well. Law enforcement also, after the fact, needs to file what's called a return, search, and inventory. So that is going to list all the items that law enforcement seized during the execution of the search warrant. It's a separate document that they then need to file with the court to tell the court, okay, from this search warrant that you granted, this is what we found. Now, after everything's said and done, just because a search warrant was granted and was executed doesn't mean that's the end all be all. If you're a legal professional and you're working on a criminal case and you see that a lot of the discovery and evidence that was obtained to charge your client was from a search warrant, that doesn't mean that you can't challenge that search warrant. I'm going to talk about the most common challenges to an actual search warrant. A lot of search warrants could have a lack of probable cause in the first place. Another common challenge is that it was overly broad or vague. It could be stale information. Another most common thing is just procedural errors. Any evidence that was obtained from that illegal search and seizure needs to be suppressed. And that, as a legal professional, is what you're going to want to look into, what you're going to want to fight to help your client and make sure that their constitutional rights are protected. This could be done in a number of ways. I've wrote a ton of motion to suppresses for the judge's review if they grant it or not. I've also wrote motions to quash a warrant. I wrote motions in limines before maybe a court hearing. And the last one, which I have heard is the most difficult, is to obtain a Franks hearing. This is, I believe it's Delaware v. Franks. It's a piece of case law that says that you can challenge a search warrant based off the previous reasons that I listed. There needs to be a specific hearing. It's kind of like an evidentiary hearing for those that are familiar with that, where you have witnesses, you question them, you admit exhibits and evidence basically for your defense. So my initial question was, do search warrants make or break a case? I would say yes. They're very important pieces of the puzzle of the investigation in terms of leading up to charging your client and potentially even after, obtaining more evidence after your client's been charged. If that was done incorrectly for any reason, you as part of the defense team is going to want to figure it out and then advocate for your client. That's our job, making sure that our client's constitutional rights are upheld. My other question was, are search warrants important evidence? Yes, they absolutely are. Again, this could be just the start or the first couple pieces to start this whole investigation into your client. And again, if things were not done correctly, that needs to be brought to light. That's part of what we look into as a defense team. So if you're interested in learning how to review a search warrant for potential legal sufficiency, what to look for in terms of complaints or affidavits, I am going to be releasing a course on this as well, just so you have information on what to look for if you're not familiar with search warrants, if you've never reviewed search warrants before, never really argued them. This is definitely going to be for you. So if you like this video, if you found it helpful, feel free to like, comment, subscribe, share. Thank you so much for your support as always, and we'll see you in the next one.